What the administration forgot, Greg, though, was there's actually a federal law, not just the Constitution, there's a federal law that says if you're born here, you're a citizen. So Trump is subverting federal law as well. But they're going off this idea that the phrase in the 14th Amendment, subject to the jurisdiction thereof, somehow means that if you're not a resident or citizen, that you're somehow not subject to U.S. laws. And so what's happening now is the government is offering settlement agreements, but just for the plaintiffs. But what they did, they lost so often, they didn't want new suits to be filed. So what they said publicly was, hey, we're reversing the termination. But here's the dirty little secret.
Welcome, and thank you all for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker, Charles Kuck and Greg Siskind. Charles H. Kuck is the founding partner of Kuck Baxter LLC in Atlanta, Georgia. Chuck served as the national president of the American Immigration Lawyers Association from 2008 to 2009. He has been an adjunct professor of law for more than 20 years, currently at Emory Law School. He was named one of the top 5 immigration attorneys in the world by Chambers and Partners, again in 2022, the best immigration lawyer in Georgia by Best Lawyers in 2022, and just previously named one of the 100 most influential Georgians by Georgia Trend magazine. Greg Siskind is a founding partner of Siskind Susser and has been practicing immigration law since 1990. He is also co-founder of AI software company Visa Law Ventures. He received his bachelor's degree from Vanderbilt University and his law degree from the University of Chicago. Greg is the author of several books and has helped in drafting a number of immigration-related pieces of legislation. He has also testified as an expert in front of the U.S. House of Representatives Immigrations Subcommittee. You are about to watch the presentation that will be about 60 minutes, and once that is complete, time permitting, we will be able to take audience questions. So if you have questions that come up, please feel free to submit them by clicking the Q&A button in the control panel at the bottom of your screen. Now, without further ado, here are Charles and Greg to discuss navigating immigration in a second Trump term.
Thanks.
Nina?
Yeah, Chuck, if I recall, we testified on the same panel.
We did, didn't we? We did.
Representatives when you were the APA president and I was just a nobody at that time.
No, Greg, you've never been a nobody.
All right. We if I now I have to figure out how to actually pull these slides up. Here we go. But we have a lot to talk about. But I wanted to, before we get into it, just sort of like we're going to be talking about 10 days of Trump or however long it's been, but we're going to be talking about it from sort of a different angle than probably what you've been hearing in the news, and it's going to be from the perspective of litigation. We're going to talk about a lot of things that have happened in the Trump administration that have sort of been in the headlines every day, but more about what's happening in the courts to deal with those particular policies. And also the format we're going to be using is I'm going to be asking Chuck questions, but I'll be chiming in as well. Another thing that Chuck wasn't an introduction, but Chuck and I are both, our firms are two of the 4 firms in an organization called Impact Litigation, where we take on basically high impact cases. We're working on a big one right now that actually is going to be discussed a little bit in one of the slides. And I always say that Chuck's the real litigator. I'm sort of like the support guy on there, which is why I'm the one who wanted to ask the questions. But it's I think we're gonna have fun with this panel. But we'll also be giving some perspective on having together, I think we've done it probably 36 times already, mass lawsuits against both the first Trump administration, the Biden administration, and now the second Trump administration. So we've been at this together for quite a few years. So Chuck, let's get going on this. So we're going to we'll start by talking about these cases. We're also going to have some time to talk about mandamuses and APA actions and what that means for people that want to actually do their own litigation and how you can help your clients by going to federal court. So we'll have some time to talk about that. And then hopefully we'll have some time at the end to take some of your questions if we've done a good job managing our time. So let's get going.
You're very optimistic on time. It's awesome.
Let's see how far we get.
Yes.
All right. So Chuck, the headliner right out the gate with with this administration was Birthright Citizenship, something that I think we sort of thought was kind of a jokey thing that they could actually mess around with that for a long time. We knew in the first Trump administration they started talking about this, and they've been talking about this for the last several years, but we didn't think that this was a thing. But it turns out it's a thing on there. So why don't you tell us a little bit about what this executive order does and where we are in that litigation?
Well, this is one of those fringe law topics that fringe law professors have talked about for years, that nobody in their right mind thought they would litigate, but it's now being litigated. So basically, the Trump administration issued an executive order, one of the earliest executive orders. It basically said, starting on X date, the next date I think was February 17th, a month out, if your child was born after that date, and you or your husband or the father of the child were not lawfully in the United States as a resident or a citizen, so if you were undocumented or if you're on a visa, your child was not a U.S. citizen. Now, their legal theory has been in disrepute since about 1894, since the Supreme Court ruled on Wak Kim Ark, but really, for decades before that, it was never considered a valid legal theory. And our entire country is based on the premises, if you're born here, you're a citizen. But they're going off this idea that the phrase in the 14th Amendment, subject to the jurisdiction thereof, somehow means that if you're not a resident or citizen, that you're somehow not subject to U.S. laws, I guess. The reality, though, is that phrase was well defined in 1868 when the Constitution, 14th Amendment, was passed, and it meant diplomats, and it's always meant diplomats, and that's what it means. Children of diplomats are not as citizens. What the administration forgot, Greg, though, was there's actually a federal law, not just the Constitution, there's a federal law that says if you're born here, you're a citizen. So Trump is subverting federal law as well. My favorite quote, perhaps, of all the litigation we're going to talk about from one of the judges was in this case, where she said, this executive order is blatantly unconstitutional.
Yeah.
There you go.
Yeah, that opens up like a lot of a can of worms potentially ethically as well for the lawyers that are arguing for the administration side as far as what they can do or not.
But I will have to add this, though, but this is, while it's the reason that this suit exists, the real reason the Supreme Court took this case is not this, which I think they're going to toss out. I think they're looking at stopping what the administration wants to stop are nationwide injunctions by federal court judges. That is the key here. We have 3 different judges that each issued nationwide injunctions, which, honestly, Biden suffered from. The Biden administration was constantly attacked by the right, and who won a series of nationwide injunctions and a lot of Biden policies. So I'm not sure Trump really wants this because it's going to hurt them long term.
Careful what you wish for.
You have what you wish for, you might get it. I'm not sure they'll get it here. This is one of those kind of the facts of this case, and the law is really so unconstitutional. Do they really want 50 different lawsuits to be filed on this exact same issue? Something we're actually doing right now in SEVIS. So yeah, it'll be curious. Oral arguments tomorrow. If you want, or Thursday, if you want to listen to a really interesting oral argument, I would tune in on Thursday morning, Supreme Court.
All right. The next one, actually, Chuck, we can only spend we'll spend a second on it, but the Trump administration basically cut all refugee admissions except apparently for Afrikaners from South Africa.
Yeah.
On there. But this one, the reason why I wanted to mention this one is the lawsuit that's going on right now is more about the resettlement programs.
Right. The people in the pipeline. Right.
And on this, I mean, we're familiar with a lot of the great work that a lot of these organizations do, whether it's the, Catholic Services or Hebrew Immigrant Aid Society and all that. I only wanted to flag this one because these agencies, those nonprofit organizations, since this executive order, have had massive layoffs because they've been cut off from contracts for resettlement work. And not only is it causing problems now? But when Trump, when we have a next administration that is again forward thinking on refugees and wants to admit them, the infrastructure is going to not be there, and it takes several years to basically get to that point. And that's, I think, what the real concern is. Aside from the fact that refugees aren't getting here, is even when Trump is gone, this is going to have a an impact beyond that. So they've already had some initial success, the refugee organizations, on this suit to force the government to continue funding. But it's one that is sort of a common theme, I guess, we're going to see, which is early wins on TROs and preliminary injunctions to stop whatever action. And then the Trump administration's plan is to hopefully win on the appeals. Would you
Right, and that's what they're counting on, is going to the Court of Appeals or even the Supreme Court. The case that's on this, though, is really only about 12,000 people that were in the process of resettlement. Those are stayed; they are still resettling them, but that's it. It's 12,000. Last year, we took in 150,000 refugees. We've resettled millions of refugees over the years. We're going to stop, and it took the Biden administration 2 full years to get back to where we were a decade ago. So it will take the next administration all 4 years to get back to a regular refugee settlement program when that happens.
All right. So, Chuck, we have 900,000 people that were admitted under parole programs from the Biden administration. And the Trump administration is trying their best to kill those programs. So where are we in that legislation? What's your thinking as far as what's going to happen?
Well, when the president obviously created this, Biden, the president can end this. But there's a way to end programs like this. And the Trump administration basically refuses to follow the process to end these programs, much like the Biden administration used a process to create the program. So a federal court judge has put a 6-month hold on this as of April 14th. So these folks are here till October. Long term, the Trump administration is going to win on this. And they've obviously stopped accepting new people. And the issue is, what do you do with the 900,000 people that are here? I think you have to take a look back, because why did Biden do this? Biden did this because he was met with a flood at the border of people coming from basically 4 primary countries. You had Haiti, you had Venezuela, you had Nicaragua, and you had Cuba. And they were coming because of the conditions in those countries. So he said, you know what? Let's come in legally. You can apply for asylum when you're here. We'll give you a work permit, and we'll figure it out. Which was better than having more millions at the border. And in fact, it worked. They did reduce volume dramatically at the front at the borders. But at the other hand, it didn't really have a long-term solution to the problem, because really only Congress can offer the long-term solution. So at the end of the day, these folks will lose their work permits. But that doesn't mean they're being deported. What that means is they need to apply for asylum, since most of them they're all from countries where asylum is a valid basis. So most of these folks are going to be here for a decade. I mean, they just are, given the nature of our asylum system and the nature of our immigration court system, because now most of them have now been here well over a year, but they're getting close to the 2-year mark, which we'll get to know one of your talking points, when they will have to go through a court process. So I think ultimately, while the programs may end, these folks aren't necessarily leaving that quickly.
I'm going to skip the next one. We're going to go back to it in a second, because TPS is sort of a similar issue as far as similar populations. And there are a lot of people who are like the Ukrainians, for example, and the Afghans who have both TPS and parole. So TPS is temporary protected status. One key difference is the parole programs are sort of they're both based in statute, but the parole programs are sort of always been on shakier grounds, and that's why there's been the Biden administration got challenged on some of the things that they were doing there. But TPS is statutory, and there's also been an attempt by the administration to, even as late as yesterday, with the Afghan TPS program, to get rid of those. But historically, we know from the first Trump administration, it's not so easy to get rid of a TPS program, at least the
Oh no.
way they did it first time. So even though the president has a ton of discretion to start a TPS program, it's not necessarily that easy to end a TPS program. So I was wondering if you can talk a little bit about that litigation before we go back to the Alien Enemies Act.
Yeah, the main group that's focused on the litigation is Venezuelans, because Venezuelans is the largest TPS group in the United States. Many of the folks that came on the parole program entered into the TPS program thereafter. But to end TPS, the secretary has to show that there's a change in circumstance that caused the designation of the TPS in the first place. And we all know nothing's changed in Venezuela.
Right.
It's like
Or,
nothing's
or
changed.
Ukraine
Or Ukraine or Afghanistan or Syria. Well, Syria may change soon, but some of the others, Cuba, nothing's changed there. Nothing's changed in Haiti. And the reality is, when Noem canceled the Venezuelan program, she was like, "I hereby cancel it," and that was it. So the courts have shut it down and extended it, saying, let's litigate this issue. So the TPS there's two levels for Venezuelans. There's two TPSs. There's the original, which expires in September, and the second one, which expired here in April, but it's now extended for 6 more months. So at the end of the day, they're both going to be around, I think, for several more years, much like the last time the president canceled the El Salvador TPS. And was never successful in doing so. And by the time it became important, Biden was president. So these programs are going to be around a while. But what it's done, Greg, is really scare people.
Yeah.
Right. And so there are some people that have left, but most are just hunkering down, trying to figure out what they're going to do next after this TPS ends. But I suspect that almost every country's program will be ended on TPS, except, oddly enough, this is my prediction, Greg, El Salvador. El Salvador and Honduras are currently basically the two oldest TPS programs. Remember, the first word is temporary. They've been around since 1999 and 2000.
Hurricane Mitch.
Hurricane Mitch. And I don't know, I was in El Salvador recently, and I can tell you, Hurricane Mitch is long forgotten in El Salvador. So I suspect, though, that it will not disappear for El Salvador if he wants to keep detaining people in that hellhole prison they have down there. My prediction.
Also, one of the reasons these programs exist is also a lot of people are sending money back to their home countries, and that's that's an important consideration, particularly from our big ally in El Salvador.
Yeah, I would note today that somebody introduced a bill in Congress today to put a 5% tariff on remittances. So the attack continues on every level of immigrant in the United States.
All right. Alien Enemies Act. So this is another one that we kind of thought was a joke at the beginning when they were starting to talk about it, but now it's obviously become one of their big go-tos.
Well, when you use the word invasion over and over again, and this is kind of an example of Orwell. The speech and the way you use speech can influence people's way of thinking. So that there's an actual invasion. Some organized foreign government is sending troops to the border. That has not happened, really, since 1812. And it certainly has not happened today. And a Trump appointee judge in Texas actually ruled that and said there is no invasion. And if there is no invasion, there is no enactment of the Alien Enemies Act, period. It's a prerequisite to this, because only the Congress can declare if there's an invasion. And Congress has not such declared, and that's why the efforts under this regard are being struck down, both in Texas and in I think it was Maryland or New York or someplace. I suspect that this will run out of steam pretty quickly, because there just is no legal basis to move forward with this. Doesn't stop them from arguing it, but I don't care how many judges you put on the Fifth Circuit, you're not going to get around this.
Right, and the idea basically here is, can they? If there's due process required and that's basically what this is about.
It's all about due process, right?
Whether they can remove people with due process or not due process. And right now there's a long backlog in immigration courts, and it takes a while to remove somebody because there's such a backlog. There's not enough judges. There's not enough resources that are being put into the courts. And so they're trying to do a short circuiting of that particular problem. And that's also, I think there's another slide on expedited removal, and it's the same idea there in terms of the way that's being turned around. But that is what they are trying to avoid, is having to bring judges into this process so that they can deport a lot more people. And this,
you've heard Trump say this repeatedly in the last week. We can't possibly give due process to 20 million people. As if that was an option.
Yeah.
as if it was an option, which it's not. Even and the courts have repeatedly said it's just not an option. And I will tell you, Greg, having taught law school for 25 years, due process is whatever Congress says it is, as it applies to foreign nationals. So Congress could, in fact, limit due process, but they haven't, and therefore there's an element, the level of procedural due process that's due anybody who's in the United States.
All right, so let's we're moving on to you say SEVIS, I say SEVIS. That's how I've always been taught on there. But this is the Student and Exchange Visa Information System, Chuck. So why don't you tell a little bit about what this is about, and then also you talk about our litigation.
Yeah, just 30 seconds on SEVIS. SEVIS is a program created post 9/11 to track every foreign student in the United States. It is a system by which foreign students exist here. They enroll in it, they pay to enroll in it, they use it to get a visa after an I-20 is issued. Once they're here, their grades are in it, their classes are in it, their work is in it, their addresses are in it. It rules their life. So if SEVIS is terminated, they lose their status. They lose their ability to go to school, their ability to work, their ability to change status, to adjust status. It's an overall great impact. Sometime in early March, someone at ICE, which runs this system, decided that they should make sure that there are no students in America that are bad people. So they took the 1.2 million people currently enrolled in SEVIS. Most of them were in the United States under F1 or M1 or J1, collectively the student visas, and run them against the NCIC, the National Crime Information Center's computer, which is not to be used for the purpose they used it for, by the way. That's a user agreement issue. And they came up, of the 1.2 million, they had 6,700 people who were hits. Instead of then investigating, which their then rules required them to do, they contacted the Department of State and said, hey, we've got 6,700 people here who got hits in NCIC. This is according to ICE. That state then said, revoke their SEVIS. I don't know why ICE is taking orders from the Department of State on a program they run. So they did. They just revoked all the SEVISes. Now, this wasn't necessarily 6,700 different people. We think it was somewhere between 4,000 and 5,000 people. But they were things like a speeding ticket, a DUI 10 years ago that had then been resolved and had re-entered on a visa. They were
being a crime victim themselves, not actually ever being arrested for anything, just being in the system as a crime.
Yeah, they had an airport problem. They went back and fixed it. So what ICE did is revoke all the SEVISes. But here's the best part. They didn't tell anybody. They didn't say they did this. They just did it. And what happened is some foreign student advisor, DSO up in Vermont, was just checking her system and said, I wonder why Pablo is canceled. Oh, wait, there's Maria canceled too. So she calls her friend at a different school. She goes, I had Mike and Bob canceled too. Pretty soon all the DSOs were saying, oh my God, I have a dozen students canceled. What's going on? Which then very quickly led to the litigation that we filed. Great.
Yeah. Yeah. And so there's been early success, and there actually are quite a few suits that have been
200 plus.
almost uniformly successful. So
Yeah.
I don't know if anybody's actually had a loss, but
One was simply referred out to redo their complaint. The rest all won, 50 TROs, preliminary injunctions. And so what's happening now is the government is offering settlement agreements, but just for the plaintiffs. But what they did, they lost so often, they didn't want new suits to be filed. So what they said publicly was, hey, we're reversing the termination. But here's the dirty little secret. They didn't reverse it retroactively. So now all these students have a gap in their status, except for the plaintiffs who won TROs or preliminary injunctions, who were reinstated as of the beginning, like our plaintiffs. We have about 133 plaintiffs, another 250 that we're currently litigating. The government is now offering settlement to the cases, which basically says they're all retroactive. But if you didn't sue, you have a problem.
yeah, and an open issue right now that is going to be harder for us, but we're hoping to have some success is suing the State Department regarding visa revocations. There's this concept called consular non-reviewability that is what the government is no doubt going to argue, and it is not it's not 100% no questions asked, no review policy, but it's definitely going to make it harder. But that's part of this is also that. Even if we're successful here, if the State Department, if we're unsuccessful in the State Department part, it's going to make it very difficult for people to travel outside the United States at any given point, and that's going to be an ongoing problem as well. All right, Chuck, let's move on to the sanctuary cities.
Oh, good.
This is sort of a rerun from Trump 1, where they lost on this issue. Why do they think they're going to win this time?
They're not going to win this time. In fact, they've already lost. The Circuit Court, a district court in California, just put an injunction in place on this policy as well. But it's not just sanctuary cities. They came out today that they're denying federal FEMA emergency aid to any state that doesn't cooperate with ICE's enforcement. So it's not just sanctuary cities; it's actually beyond that. The literally linear sole focus on numbers is why they're doing this. The reality is, when you say sanctuary cities, what you're saying is cities that don't hold people according to an administrative hold put on by ICE. ICE has the legal capability of getting a judicial hold on anybody they want to. They can do this. It's easy for them to do, but they choose not to do this. I don't know. They're lazy. I don't know why. So instead, they put an administrative hold, and a number of states say, "Look, that's not enough. If you are wrong, we get sued for depriving somebody of their liberty, and we're not willing to take that risk." So yeah, the sanctuary city punishment is also likely unconstitutional, and has been struck down. Will be struck down again, but doesn't stop them from doing it.
All right. IRS. This is one that's kind of scary for people because for our whole careers, the IRS has been saying, we don't share information. If you file a tax return with a taxpayer ID number instead of a Social Security number, we are going to take your money, and we are not going to report anything to the immigration agencies. But the Trump administration's changed that policy. And now it's led to litigation against the IRS. So what do we know about that?
Well, the Trump administration won this case. And a federal court judge ruled yesterday that ICE can continue the information sharing. Now, the information sharing is not about every immigrant in America, at least not yet. It's about those with removal orders that ICE is seeking. So ICE has to go to IRS and say, look, here's the list of people we're looking for. Please give us the information so we can try to track them down. And the judge said it's perfectly fine to do that. I'm shocked by that. Obviously, it'll be appealed. But end of the day, what this is going to result in, Greg, is people simply no longer filing tax returns. Yeah. Would you?
No, and I'm not so sure it's in the best interest for the country to stop that money from coming in. And that's also the same with Social Security Administration over the years. I don't know how many, they probably have $100 billion sitting in Social Security trust funds that are not, that are.
Oh, Greg, I think it's somewhere in the neighborhood of about $85 billion a year.
Wow.
It's hundreds of billions of dollars that is there because people that are not ever going to use the system are actually putting into it. It's honestly kept Social Security afloat for an additional decade.
All right. Dismantling of oversight offices. So one that I think really upset a lot of immigration lawyers and should upset the country is this one with the end of the ombudsman's office, at least for now, on there. There is some litigation on this as well. And it seems like these sort of thematically, Chuck, where they illegally shut down, an office that's been authorized by Congress, that there's been some success in the courts, not just with these agencies, but
with others as well. Right.
Do you sort of see this in the same category as those others? Were you optimistic, pessimistic about the long term, about whether these agencies are going to survive, or do you think this is pretty much going to be the end?
I think ombudsman is not coming back under the Trump administration, even though Congress not just authorized it. There's actually a report every year due in Congress from the ombudsman. But if you don't appoint an ombudsman, there isn't one. So yeah, I think the litigation may say you can't close this office, but if it's not staffed, how is it relevant? So yeah, and you have to wonder why. Why does the government not want an ombudsman? If you don't know what an ombudsman is, somebody who advocates for the public with the agency on errors that they've made. And this ombudsman actually has real authority, and he just got rid of them. I mean,
by the way, we deal mostly with the DHS ombudsman, but there's also an ombudsman that deals with detention.
Yeah.
And I think the CBP has another one.
Yep. All gone.
And they're they're basically watchdog agencies, that are reporting on what's going on. So, all these things that are scary that are happening in the administration on the immigration front, not only are they happening, but the agencies that are, these agencies within the government that report on what's happening, they're not there to report. So it's really troubling.
Well, what's interesting is that when you think about the kind of context of this, this is more evidence of Congress giving so much power to the executive branch that when the executive branch says, I don't want to do this anymore, Congress just sitting there on their hands, and they don't know how to react to it, especially when the Congress supports the president's action. So, it's a troubling issue for Americans. A lot of just normal Americans who didn't use lawyers to file their paperwork. When it got screwed up, they went to the ombudsman for help.
Yeah.
There's now nobody to come help.
Yep. All right. Enforcement in sensitive locations. So before we, this policy's been in effect since the Obama administration, I believe.
Yes.
But basically, no ICE raids in hospitals and healthcare facilities, no ICE raids in churches and houses of worship, and no ICE raids in schools on there. That memo is gone. That's in litigation. What have we seen on that front?
Well, it's actually not longer in litigation. The federal court ruled that because ICE has not done it, and there's no evidence they will do it, that the litigation was premature. I know I actually was hired by a group of churches here in Atlanta to file that litigation here in the Southeast. And when the Maryland case was dismissed, we said, look, we're not going to be successful here until something happens. So, it's the question of training these churches. If ICE is there, ask them to leave. It's private property. They have no right to be on your property. So you can say, please leave. But understand, until something happens, really can't litigate this issue. We know that ICE agents have been tossed out of some private schools and been asked to leave a couple of public schools in recent weeks, but we haven't seen the focus yet by ICE on these sensitive locations.
Okay. All right. Let's move on. Registration. Well, that was also something that kind of came out of the blue. They didn't try that in the first Trump
They
administration.
didn't try it, but we knew it was coming. It's in Project 2055. It's been in the law since 1940, the Registration Act. So this is not new. It's just that we stopped doing it in 1973. You just stopped requiring people to register. Now, the requirements themselves are kind of strange and really hard to follow for a lot of people. Who is supposed to register? First of all, it's not everybody. So if you came in and you were a resident, you don't have to register unless your child was under 14 when he got his green card. Then you do have to register for your child. If you're undocumented, you had to register unless you had previously filed an application where they took your fingerprints. So it's very complicated. They also put a 30-day limit on it, which just ran yesterday. Yesterday was the 30th day. No indication of what they're going to do now. We know as of the first 3 weeks, only 47,000 people had registered. The penalty for not registering, Greg, there's nothing in the law that says you're deprived of benefits in the future. You can't do this in the future. What it says, if you don't register, you can be brought to trial. And if the government can prove that you willfully failed to register, you'll be convicted of a misdemeanor with a $1,000 fine with up to 6 months in jail.
Right. And so far, we haven't heard about anything happening in that regard. There was a case
in Arizona.
Oh, there is a case. All right. Well, there also was a case challenging it, and it didn't succeed at the early stages.
No, not early, because they legally can do this. The question is, did they put it out as an emergency rule? They hadn't really followed the APA. But I would suggest very few people registered. I know, obviously, as lawyers, we can't tell people not to register, but we can tell them what the penalties are for not registering, and then they can make their own decision about what they want to do. Obviously, when people ask, why are they making me register? And the answer was, why do you think they're making you register? And their answer always was, well, they're going to come pick me up. I said, I don't know, but that seems like the thing what they're doing.
Yeah. Okay. But the funding freeze for immigration services, we kind of already been talking about that.
Right.
But that's this is sort of different than the refugee agencies. This is other kinds of immigration services. And there have been lawsuits here. I don't know if there are a bunch of little lawsuits or there's one big lawsuit.
I think there's a bunch of little lawsuits around, but none of them are moving very fast. And the reality is, one of them did win, so they were successful in restoring some services for people in detention. But there's things like no representation for kids in court, which is insane when you think about it. In fact, if you want to watch a great segment on that, watch what's his name, John, the comedian, has his show at night. I want to say John Roberts, but used to be
John Oliver.
John Oliver. Google John Oliver and kids in court. You'll watch a really great segment on this. The reality is the federal government does help immigrants navigate a very complicated system, especially those that can't navigate it themselves. That's gone now. It's gone.
All right. Expedited removal and due process. So that's a big one. Even though it's sort of at the end of this list on here. And why don't you explain what expedited removal is, and that why it's a pretty powerful tool for the administration to be using, and what their limits are, and what this litigation is about.
Sure. In 1996, Congress passed the Illegal Immigration Reform Act and Immigrant Responsibility Act, or IRA. In this, they created the expedited removal to give basically Border Patrol agents at the border, at the airport, then INS, the power to deport people. If you don't meet these criteria, we can just deport you. And it's been in effect now for almost 30 years. Hundreds of thousands of people have been expedited removed from the airport, but it also had a provision that had never really been used until the last Trump administration, which said it applied at the airport or to any alien inside the United States for less than 2 years. So they could pick you up on the street, and if they determine you've been here less than 2 years, they could literally just bring you to the border and just kick you out. They could just...
Who's the burden of proof on in that situation?
It is not on the Immigration Service. It is on the foreign national. So, obviously when we saw this coming, we knew Trump elected, we began advising people, you need to have in your possession evidence that you've been here longer than 2 years. Now, that kind of conflicts with the other information we tell people is don't talk to them. But if they're looking at deporting you, it's either not talking to them or being deported. So obviously, look, I've been here longer than 2 years. Here's my evidence. I've been here longer than 2 years. They then can't legally expedite remove you. It doesn't mean they won't, but they're not legally supposed to do that. They have not really used this extensively yet. They used it a little bit, but their plan was to use it against the parole people, because most of them had been here less than 2 years. But now that they're hitting 2 years on those, you're losing those numbers that they can ER, expedited removal. But that is certainly something that's a very powerful tool for ICE to use, and one they want to use. And certainly they ask everybody they arrest, how long have you been here? And if you say I was here a year, boom, no, it means no hearing in front of an immigration judge unless you say that you're afraid to go back, and you don't even get a hearing then. You get an interview before an asylum officer to determine whether you have any credible fear of being removed.
So is there any national litigation on this, or is it all individual suits?
It's all individual. Because the reality is what the law allows this. I mean, this is what the law says. It's just we've never done it before because, frankly, it's draconian. It's just draconian. And again, we haven't seen it in the volume yet. But we may see it in volume over the course of the next year. If they don't do it within the next year and a half, it becomes an irrelevancy, because first of all, we're not seeing a lot of people come in through the border. And second, people are wise to carrying evidence around if they've been here longer than 2 years.
All right. So the last thing is sort of a holdover issue from Trump 1 on unaccompanied and separated children and kids, basically, that are coming by themselves. So what's happening on that front right now?
Well, Biden created an office for reunification of kids, and they reunified a couple thousand families with their kids. But if my memory is correct, I think there's over 3,000 or 2,500 kids that have never been reunited with their families, and Trump dismantled the office. The office doesn't exist anymore. But there's no program in place to reunite families with kids. Now, what is happening, interestingly enough, Greg, is they have hired USCIS officers and contractors, as well as ICE agents, to go around to unaccompanied minors' houses where they're supposed to be to see if they're really still there, ostensibly to check in whether they see they're trafficking. These kids have been trafficked, but in reality, they're meant to scare the kids into leaving the country.
There you go. All right. We're going to change topics now and get into for those in the audience that want to sue, these are sort of your entrees to litigating at the federal level. And this has been, I guess on mandamus, this has been since lawyers learned to sue at the, I guess it was probably in the Obama administration or even back earlier than that. But there was a period of our career where it was really rare for people to go to court. And then it's sort of like the floodgates opened probably about 10, 15 years ago on there. But mandamus actions are probably 80% of the federal immigration related actions that are there, if not a higher percentage of that. Why is the mandamus such a powerful tool? Why don't you tell us sort of like what it is, and why and it's gotten harder too in some respects.
Oh no, absolutely.
But we've done some of our mass actions have been mass mandamus actions when there's been no action happening for a group of people. But what is the Mandamus Act? Why is it an important tool for immigration lawyers to and lawyers wanting to go to court?
Yeah, there's generally two ways to sue the government when they're engaged in delays. This is a common law writ. It's designed to force government agencies, government employees to carry out a mandatory act. They're required to do something. They're not doing it. You say, judge, order them to do it. I mean, that's you can't hold them at gunpoint, right? You get a court order to do it. And what's happened is really starting in the Bush administration, you began to see these massive delays. I don't even remember 4 years for a green card through marriage, just crazy stuff that came out of 9/11. And that's when mandamus is starting moving. Really, I've been doing it since 1989, but we really started pushing them then. And we really saw it under the Obama administration, who again was delaying work. Now, that could be because the agency itself is overwhelmed. There was clearly policy reasons that had happened during the Biden administration and Bush. And they're actually intentionality under the Trump administration of basically not working on cases. We're just not going to work these cases. Biden did the same thing. We're not going to work these cases. We're just going to sit aside. So, for example, one of the cases Greg and I brought was on a 601A waiver. 601A waivers are for people that need to be forgiven in advance so they can go get their green card outside the United States. And the processing times went from 6 months under Obama, 12 months at the end of Obama, even 12 months under Trump, to 4 years under Biden, just like overnight. We found out why. They just didn't work on them. They just stopped working on them. So we sued to try to move that forward. So as individuals began to realize how easy it is to file a mandamus action, which you can file under both the Mandamus Act in 28 U.S.C. 3061 or under the APA, the Administrative Procedures Act in 5 U.S.C. 7061, to compel agency unlawfully withheld or unreasonably delayed. The key here, though, Greg, is it has to be an unreasonable delay. And this is the word, like a lot of different words. It means whatever the judge thinks it means. Is it unreasonable to take a year to issue a fiancé visa? One judge in Washington, D.C. said, yes, it is unreasonable to do that. Is it unreasonable to take 4 years to adjudicate a 601A waiver? Maybe not, depending on the workload. So we've seen a lot of judges who early on in the aughts and the teens, man, they would just order, yes, it's been taking a year to naturalize somebody, I'm unheard of. But as more of these cases were filed, I think judges began to think, my God, this agency really is overwhelmed. And if I order them to do it, they're skipping the line. And so the government began to argue, they're just skipping the line, a line created by unreasonable delay. But now you have to pick and choose where you file. For example, do not file a mandamus action in Washington, D.C. Just don't. You're going to lose. Unless it's 4 years overdue, you're going to lose. So you want to know the court you're filing in before you bring a mandamus action, and you want to know the type of case you're filing. For example, I was contacted this morning by an individual who had been put in administrative processing at a consulate, and he wanted to sue. And I said, no. First of all, while I agree it's unreasonable, there is no federal court judge in America who will. So we're not going to waste your time, your money, or my time with filing this. Call me at a year. So we have began to change how we look at mandamuses. But this is not just necessarily in delay. Sometimes they're just not doing something that they're required to do. And I'll give you a great example. You get it denied an I-130, a marriage petition, and you can appeal that. And you file the appeal. The appeal is filed at the local office, not at the appeals court, the BIA. Well, unless the local office sends it forward, the BIA doesn't even know it exists. So you can't sue for delay, because there isn't a delay by the Board of Immigration Appeals. You sue the agency for failing to carry out an act that they're required to do. So again, you have to look individually at the case. And, there are some lawyers that have sold kits, how to sue the government. Here's the kit to sue the government. And what you end up getting is a lot of really crappy cases suing the government that lose, that then set really bad standards for the law.
So Chuck, let me ask you on the mandamus cases. I mean, there's two ways to make the argument. One is that that it's just too long as a general matter. And then the other is that your case is taking a lot longer than the published processing times on there. And we've seen the government kind of play games with published processing time. They have these ranges now that are so, the outside end of the range is so long that, virtually nobody is probably outside that long end of the range, so that it cuts down on the number of suits. But what is the, what do you think the secret is to, do you tell people to, if the processing time itself is completely unreasonable, is it okay to sue? Or do you basically say it's got to be X amount of months beyond what the published processing times before you think they have a decent case?
Well, you have to look at the individual court you're going to be suing in, look at their prior recent precedences on these cases, look at who you might get as a judge. The reality is, if you're within the time frame that the government is ridiculously published, you're not going to win. You're just not going to win. The judges, they are overwhelmed with these cases. And I will tell you, none of them like immigration. I have yet to meet a federal judge that said, my God, I'm so glad I got another immigration case on my docket. They hate these cases, so they're going to try to get rid of them as quickly as possible. You want to be looking at a case that you're well past the established processing time, and more importantly, that you have made other efforts to seek adjudication. You have written to them. You have contacted your congressman. You have done an info pass if it's even possible on your case. You've reached out in every way you know how, and document each of those efforts. And only then, when you can show actual harm to you that is greater than the harm everybody else is suffering, do you bring that mandamus.
All right. So if you win on the mandamus, you get the judge, your win is basically the judge telling the agency you have to work on this thing now.
Right.
Any concern about whether that affects whether you're going to win or lose on the case?
I would tell you no. In the past, we have seen a couple incidences recently where we thought retaliatory RFEs were issued based on nothing other than the fact that they were forced to work on the case. Then we told the U.S. attorney, this is retaliatory. And we're going to tell the judge this is retaliatory once we respond to it. But at the end of the day, you have to expect not necessarily an approval. So if you've got a marginally approvable case, don't file a mandamus, really. You want to file a mandamus on a case that you know that they have to approve, because there's nothing controversial about that case. Now, you can bring a mandamus on marginal cases. Just understand you're more than likely to get an RFE.
Okay. Chuck, I just was bringing up the, this one of the big, it's a big, if you hear an objection, it's usually people who think they're going to be punished for suing.
Right.
Which
I have not really seen. No.
Right. And then also they're obviously concerned about the cost of suing itself on there, which, it's like it is what it is on there, but you also have to think about the costs of delay and kind of weighing that. But aside from losing on there, are there sort of warnings that you give, as far as is there any bad?
You have to give this warning now because of the Trump administration. If they deny you, they're going to put you in removal proceedings.
Yeah.
So you have to give that warning now, and understand now, if you're out of the country, you're suing the Department of State, it is what it is. But if you're here and you're suing because they haven't adjudicated your adjustment of status since 2017, and I actually have one of those cases, Greg, yeah, I would sue on that every day of the week and twice on Sundays. But understand, if you lose, you're going to be put in removal proceedings. And that's not necessarily a bad thing for some people, because you can renew whatever you're doing in removal proceedings. I will tell you this on call.
You have an executive order and say that where they're talking about going after the immigration lawyers if you're filing something completely frivolous.
Right. So obviously don't file junk. I mean, obviously you want to have a really good case. But understand this, costs when to file a case, it's not a lot of effort to file a complaint. The costs come when the government fights back. You got to do a motion to dismiss, you got to do a motion for summary judgment, and you've got to make sure you're talking to your client about that before you even begin the case.
Okay. APA framework. I mean, this is sort of basically along the same lines as Mandamus, but are there key differences between the two that you should pay attention to?
A lot of times you want to file under the APA and not Mandamus, mostly because the APA is more mandatory than a Mandamus action is. Under the Mandamus Act, I always include both in my filings, and the judge can pick which. That's why I love alternative pleadings. They can pick whichever one they want. The facts are always the same, but again, you need to go to the idea of unreasonable, and then look at the track factors. The track is a case out of the Washington D.C. District Court where you lose the rule of reason. The rule of reason is apparently, we used to think it was a pretty solid thing in our favor, but it's not so much anymore, because reason apparently is up to the judge and not to anybody else's reason process. There are very few statutory mandates. There is there's a really great statute that there's a sense of Congress that NIVs should take 30 days and IVs should take 60 days. Judges just blow that off. So there are some things that used to have mandatory processing times, like EADs, but basically Obama got rid of those. So at the end of the day, you really need to focus on the harm that your client is suffering and the lack of harm the government will suffer if you really want to prevail on these. Do you want to talk about a deck action real quick? Do you have a slide on a deck action?
Do we have a slide on a deck action?
I don't know.
I do. Talk about it anyway.
All right. So the declaratory judgment action is the other type of case you can bring. This is when the Immigration Service makes a mistake. And I know you're shocked. The Immigration Service made a mistake. I'm shocked by that. Declaratory judgment is, hey, federal judge, declare the law to this government agency. Declare what this is. And so if they make a decision on an EB-1A, this person's not extraordinary, and they meet all the criteria, you can bring a deck action on that. You can bring a deck action on a regular I-140, on an H-1B, on an L-1. What you cannot bring a deck action on is a national interest waiver. And that's because of the jurisdiction stripping provisions of 1252, which basically, because NIWs are discretionary, there's no federal court jurisdiction on that. But again, if you make a mistake, you can go after them on a declaratory judgment action.
All right, Nina, do we have any questions yet?
Yeah, we do have a few. Our first question is, Carol asks, I have a former student who's 7 years old, whose father is undocumented and has been deported previously. The Nassau County Court made the father the custodial parent and legal guardian, and he is the payee of the student's disability benefits. This American-born student does have medical issues. I'm concerned about protecting him if and when the dad is deported. Do you have any thoughts or commentary on that?
Yeah, the guardian, because Trump's coming for everybody. The reality is, as of yet, the AI computer doesn't appear to be taking in state court judgments for juveniles like this. So unless he's caught up in some sort of raid or some sort of accidental being stopped by the police and putting into ICE custody, I don't see them encountering him. But again, if he does I didn't know, does he have a deportation order? I may have missed that first part of that question.
It's unclear. It says that he's been deported previously, but it now is.
All right. Well, you should be concerned. If he's been deported previously and came back, he is not entitled to any due process. He can just have his order reinstated and deported. So you might want to plan for provisional parenting of the U.S. citizen child in the United States until the child is of age to parenting themselves.
There are efforts in a lot of places, particularly with the family law bar, to put these guardianships in place so that they sort of spring into place when a parent is removed from the United States, and allows whoever's designated to make decisions about healthcare and school and all these other things for the child, that if the child's going to be if the plan is for the child to remain in the United States. Chuck, that raised another issue as well about instances where children have been who are U.S. citizens have been deported with their parents, and that's obviously that's not supposed to happen for U.S. citizens at the parent, but it needs to be really clear as well, a parent in that situation, that the children are citizens and are not to come with them. But do you have any advice sort of in that situation?
Yeah, one of the things we've been doing since Trump was elected was helping people do guardianships, so that they can identify someone who will pick the child up from school, who will care for the child in their absence, as well as a separate power of attorney for somebody to have access to funds or property. And you can limit a power of attorney to certain things to care for that child until they can be reunited or while the child remains here. The interesting thing, Greg, is, a child's born here. When the child's 21, they can sponsor their parents. So basically, anybody who's deported who has kids here is going to come back in 10 years. They're kids. So we're just kind of playing musical chairs with people's lives to make Stephen Miller happy.
Yeah. Okay. Nina, you said you had another question.
Yeah, absolutely. So our next question is, this is from Sandy. She says, sorry if I missed it, but Trump Gold Card status. Can you elaborate a bit more on that and any thoughts you have?
I can talk about that a little bit. So this gold card is a musing. I say not amusing, a MUSING, a musing, which is basically it can't happen without congressional action on there. You can't just create a green card category out of whole cloth and grant somebody permanent residency without Congress actually creating a category for that or a mechanism for that. We don't really have anything like that. And it's just now, I understand that Congress, Cornyn and Senator Cornyn and others are working on legislation to try and push that through. But Chuck, I don't see how you can do this at this point.
Well, it can't go through reconciliation unless they want to ignore the the parliamentarian in the Senate. So it's not going to become law anytime soon. The thing is, we already have an investor green card, and it's only $1 million. So why would you spend $5 million when you could do $1 million?
I will tell you the one group. So I've actually encountered people who are worth millions and are completely undocumented. There is a group of people in the United States who that category that I know somebody who's got like 200 employees and they're worth like $100 million and they've been undocumented for 40 years. I know others that are in similar situations. That would be sort of like the one advantage if they could come up with a new category that would allow them to waive all those things.
Yeah, can you imagine? That's not going to happen. Well,
so that's all. Otherwise, I tell people it's not really a gold card. It's more like a silver card. If you don't get rid of all those problems, then you're paying 5 times what you could pay in another category. The only thing that would make it worthwhile to pay 5 times what you pay in the other category is if they wiped away all your problems that aren't wiped away at the other category. And that I didn't heard is happening yet.
This idea that there's 1,000 people lined up for this, really, there aren't 1,000 people on this planet that would want to do that. They're just not.
Not at that level of money. And also the tax consequences.
The tax, become a citizen. What, now you're taxed on your worldwide income? Come on.
That's just what they want. All right. Well, so Nina, we have anything else? I think
we have a few more questions if you all have time. Chuck,
all right, we'll stay. Chuck, I know you have a hard stop, but I'll stay until
they call me to tell me out. So
okay, thank you both. I appreciate that. This next question is from Elaine. It says, what do you recommend for those who are prosecuted for illegal reentry, particularly if they have reentered several times?
Get used to wearing orange. I mean, it's a federal crime. If you've been deported and come back in, especially if you have a conviction, they're going to put you in prison. They just are.
There's not a great defense to that. I mean,
there is no defense to it. I mean, it's a per se violation. So, I mean, don't do it. How about that? I mean, I understand why people do it. I get it. Their family's here. Their life is here.
Right.
But,
you're not getting deported. You're getting to prison.
Yeah. Talk to a Canadian immigration lawyer.
Yep. All right.
Our next question is, have you heard anything regarding Cuban nationals who entered the country with an I-220A, hence not eligible for adjustment under the Cuban Adjustment Act?
Oh, I've heard a lot about this because I'm doing several of these cases. You know, there's this crazy thing, Greg, where depending on how ICE released you from appearing at the border will determine whether you can use the Cuban Adjustment Act or not. And it's literally up to whatever random officer that day was making whatever random notation on an I-94 card.
And most Cubans are coming through the Mexican border now. They're not coming over on rafts anymore.
Right. So that, you know, which would be easy Cuban Adjustment Act stuff, right? They basically wet foot, dry foot, they're here, they're good. So no, there's no fix for this. If they made the wrong notation on the 221, sorry, you're not going to adjust.
You can consular process, no, but you still have to have a basis.
Yeah, you'd have to consular process, but you're going to get a 601A waiver for your 10-year bar. So, and you probably want to get a 212 before that because you're going to have a removal order when you leave.
Yeah. Okay.
All right. Our next question is from Pavel. The question is, for non-LPR cancellation, they must show exceptional and extremely unusual hardship. As family separations become extremely common and communities and judges get desensitized to the harm, do you imagine that the systemic hardship will erode the legal threshold of what's exceptional? Then what?
You mean the 2% they currently approve is going to go down? Approval rate is 2%. How could it get worse than that? I mean, that's just the reality. The standards set by the BIA after IRA passed and this ridiculous standard was created, unless your kid has cancer or you have two heads, your spouse has two heads, you're hardly going to win these, or you're a single mom of 6 kids, you're not going to win these cases. These cases basically are time buying mechanisms. Can you buy enough time for the next administration to come in and cancel all your cases like Biden did? That's what 42Bs are. It's rare that you get a really good case that's winnable on this in the grand scheme of things. Complicated, Greg, by the lawyers that were filing fraudulent asylum cases so their clients could get the 10-year rule and the 10-year work permit. Most of those folks are facing and looking down the throat of deportation orders.
Thank you for that insight. Our next question is from Michael. He asks, have you ever filed a DEC action for a U visa denial? If so, what were the risks, issues, pitfalls? Is it worth it to file in a case like that?
No, it's a legal issue, whether you meet the standard. I mean, I don't see why you couldn't do it. I've never had a U visa denied, so I haven't had to litigate that issue. Nobody's hired me for it. The problem is USCIS has been very generous, Greg, over the years on U visas. Very generous on what qualifies. So if you're getting denied, it must, I'm just saying, I'm not arguing that immigration is always right, which they're not. You're going to have a real uphill fight on this, but I don't think there's any deference. The great news, Chevron's gone. There's no deference due to the agency on their interpretation of what this type of qualifying crime is. But, if it's all the client has, I think it's worth the risk.
Yeah, I agree.
Awesome. And we have time for, I think, 1 or 2 more questions. Kara asks, how long does the mandamus action typically take?
Well, that's a good question.
Well, that depends on your U.S. attorney. Once you serve, I always tell clients, usually around day 59, I'll get a phone call, because 60 days is the response date, from the U.S. attorney saying, hey, can I get 30 more days while we try to resolve the case? Keep in mind, the U.S. attorney's offices around the country are all half-staffed. Greg, I found out oil is even at half-staff. Not because somebody died, it's just they don't have enough staffing. So they're all struggling to meet the demand of what's coming. So I would suspect that most times you're not going to litigate a mandamus beyond the filing, and you're probably going to get a resolution within 60 to 120 days most of the time, unless there's just no valid basis for your case and you're going to look at a motion to dismiss. But
I think it's worth pointing out that that's kind of a change from Biden when they were fighting back on more of those cases to try and deter people from. There were so many mandamus cases that were being filed.
Yeah, they were fight. They don't have the ability to fight everybody.
Trying to fight back some in order to disincentivize people from filing the cases. And that's sort of why this executive order is about as well, about trying to intimidate immigration lawyers from filing these cases by threatening bar complaints or threatening, to ask for sanctions from judges and all that. The idea is the same, is they want fewer suits filed. And so they are using some pretty rough tactics to get to that.
The irony of saying file a complaint against the immigration lawyer for filing a case you don't like is the number of U.S. attorneys that are filing garbage in federal courts in front of judges today. So
Be careful what
that's
whether you go down that road or not.
yeah.
U.S. Attorney's Office.
Well, thank you both so much for all of your time and your insights. We really appreciate it. And thank you all so much for submitting your questions. We want to thank you so much for joining us for another Justia webinar. As I mentioned at the top of today's presentation, if you're looking for a new way to showcase your legal knowledge and connect with potential clients, don't forget to take advantage of Justia's Ask a Lawyer platform. Whether you're an immigration lawyer or in another practice area, Justia Ask a Lawyer gives you a platform to answer potential clients' legal questions, giving your Justia Lawyer Directory profile a boost in visibility and establishing you as an expert in your practice area. If you have any questions about that or you'd like to start answering today, you can go to answers.justia.com. Have a wonderful rest of your day, and thank you all so much for joining. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.